Anyway, it's nice to be here in Hyderabad, and I'm reminded of a late Chief Minister of Andhra Pradesh who would address the gathering by saying, Aru Koti Andhra Prajalaku Namaskaramlu. For those of you who are from the northern part of India, Makara Sankranti ki Shubhkamnaye. For those of you who are from the southern part of India, I hope you enjoyed your Pongal. The topic today is recent US agency decisions and rules. There are three agencies that I wanted to talk about. The first, the International Trade Commission. The second, the Patent and Trademark Office. And the third, the Federal Trade Commission. The US ITC is an agency where a patent holder can file a complaint and request the agency to institute an investigation against products that are being imported into the United States that allegedly infringe a patent. Upon receiving the complaint, the ITC then requests the recommendation of the Office of Unfair Import Investigations and decides to institute the investigation within 30 days of receiving the complaint. Thereupon, the case is assigned to an administrative law judge, or ALJ, who then comes up with who then issues the order on ground rules and procedural schedule. And a target date is typically set within 45 days. That is, the target date is decided within 45 days of publication of the notice of institution of the investigation. And for parties who want to protect their information, business information, and confidentiality of any information, they can then request a protective order from the ALJ. An evidentiary hearing is held, and upon the evidence that's presented by the complainants and the respondents, the ALJ issues the initial determination, which is typically 4 months prior to the target date. And the ALJ may give, as part of relief, an exclusion order and a cease and desist order. An exclusion order can be either a limited exclusion order or a general exclusion order. And thereupon, the respondent or the complaint, if they are not happy with the ALJ's decision, can appeal it to the Commission. The Commission reviews it and comes up with its decision. And there is a 60-day waiting period for presidential review. And there have been very few cases where the President has vetoed a Commission's decision. There have been only 5 cases until 1980s where the President had vetoed a Commission's decision. So there are a couple of cases that I wanted to talk about. One is a Suprema case where the complainant in this case asserted that the respondents, Suprema and Metallics, violated the 337 section by importing optical fingerprint scanners. And in that case, Metallics imported the Suprema scanners and later integrated the software of its software in the United States. And that software was allegedly infringing the complainant's patent. The ALJ in this case found that the respondents were directly infringing the patents. The Commission, upon review, looked at it and then said that, well, not really. It said that the Suprema was encouraging, aiding, and abetting Metallics infringement well before importation, and therefore Suprema was liable for induced infringement on the imported scanners. The Federal Circuit, upon review, decided, and this was the reasoning that was used by the Federal Circuit, it said that the focus, it looked at the statute 337A1BI, which said that the importation into the United States, the sale for importation or the sale within the United States after importation of articles that infringe a valid and enforceable patent. So the reasoning of the Federal Circuit was that in this case, the articles that were imported didn't infringe. It was only after the software was uploaded onto the scanners that the product was infringing, and therefore the Federal Circuit held that an exclusion order cannot be issued by the ITC based on theory of induced infringement where there was no direct infringement until after importation. Then the second case that I wanted to discuss about is the Apple's iPhone case. In that case, Samsung, which owned the 3G essential patents, then filed a complaint against Apple's iPhones. The ALJ in that case issued that the patents were valid. 3 of the patents were valid but not infringed. The 4th patent was invalid and not infringed, and also that the Samsung had failed to prove the technical prong for any of the 4 patents. The Commission then looked at the ALJ's decision. It found that only one of the patents was infringed. It then issued a limited exclusion order and a cease and desist order. And this was it was something that was very disturbing for a lot of people, since it meant that customers in the United States would not have access to Apple's iPhone. And so this is one of those rare instances where the president of in the presidential review, they looked at the Commission's decision, the Commission's exclusion order in this case, and based on policy considerations, they decided to veto the Commission's decision. So those are the 2 cases that I wanted to discuss as far as the ITC was concerned. For the Patent and Trademark Office, I think there's a lot of focus, and you'll be hearing from a lot of practitioners about the inter-parties review as a forum for challenging patents. And one issue that I wanted to bring up here is that in this case, the patents can be challenged so long as it's so long as it is within 1 year from the time of the filing of a complaint. And so there are a couple of cases that I wanted to highlight about, particularly the language in 35 U.S.C. 315B, which states that an inter-party review may not be instituted if a petition is filed more than 1 year after the petitioner is served with a complaint. So in a case called Apple versus Vernetix, Apple filed 7 IPR petitions challenging the patents. And in this case, Apple, these 2 of the patents were involved in district court litigation in the Eastern District of Texas, where the complaint was served on Apple in August 2010, and another complaint was served in November 2012. So Apple made this argument that, the IPR petition has been filed within 1 year from the November 2012 deadline, and therefore the IPR petition must be granted. Well, the PTAB, or the Patent Trial and Appeals Board in this case, said that, that's not what it is. If you look at the plain language of the statute, it says a complaint, not any complaint. And therefore, a complaint in this case is the complaint that was served in August 2010. And since the IPR petitions were filed more than 1 year after the complaint was served in that case, the IPR petition cannot be granted. Then comes Samsung versus Fractus. In this case, Fractus, which was the owner of 4 patents relating to antenna structures, served a complaint on May 7, 2009. A jury awarded $38 million against Samsung. Samsung then filed inter-party re-exams and ex-party re-exams. And later, Fractus served another complaint on February 28, 2012. Samsung then filed a petition, 2013. And Samsung filed an IPR petition on October 4, 2013. And Samsung argued in this case that the earlier petition, that the earlier complaint that was served, that is a May 7, 2009, was before the America Invents Act went into effect. And therefore, that is not a complaint under AIA. Once again, the PTAB said, no, that's not what it is. A reading of the statute, once again, means that under 315, a complaint is the one that was served in February 28, 2013, and denied Samsung's petition. Now, the question then practitioners will be asking is then, are there no instances at all where an IPR petition can be filed more than 1 year after a complaint was served in a civil suit in a district court? Not necessarily. The case is Oracle versus click-to-call text. In this case, the complaint was served back in 2001, and the suit was then dismissed without prejudice in 2003. Then in 2013, Oracle filed an IPR petition challenging the patents. The patentee in this case said, well, the complaint was served in 2001, it was a complaint, and therefore should be barred under 35 U.S.C. 315B. The PTAB in this case said, well, not necessarily, because in this case, the district court had dismissed it without prejudice, and therefore the federal rules of civil procedure and the Federal Circuit precedent treat a dismissal without prejudice as something that never existed, and therefore granted the petition. Finally, I just want to talk about FTC versus some actions involving the FTC. I know you earlier heard about the FTC versus activist case. I'm not going to go into that. But what it is that I would like to bring to your attention is that there is a pre-merger notification now that is required for parties, who enter into agreements that are classified that come under Section 1112 of the Medicare Prescription Drug Improvement and Modernization Act. What that covers is two types of agreements. The Section 1112A, which is an agreement between the generic and the brand, where they enter into an agreement and with regard to either the manufacture, sale of the generic, or if the agreement has to do with the 180-day exclusion period, then there is a requirement to file within 10 business days